Good afternoon, everybody. Great to see 50 people in these podcasts, and hopefully by the end of the series, it will be 500. It's Belinda Schwer here, trying to do my bit for saving adult social care law from disappearing into the history books as an area of law that people just kind of found too difficult in the end. The podcast series is about the principles underlying adult social care, and we're going to be figuring out where on earth they come from. Because the training I do with local authorities these days makes me fear that they're having to do so much work so fast that the new people coming in can easily start with their tasks without really knowing where the principles come from. And that means that you end up wasting more and more time thinking about the ambiguities in a client's situation and not really knowing how to frame even how to think about that problem. And if that's difficult for the staff, you can imagine how much more difficult it is for the human beings and their families who are affected by the difficulties in adult social care. The logistics for these podcasts are up on the screen, and I would ask you, if you can, to take a quick photograph of that, because of course, if you just do the recording, you can't still, well, you can still the screen, but you can't click on those links from the YouTube recording. Okay, 5 seconds to do that. 5, 4, 3, 2, 1. And now I'm going to go into the actual materials. As I've said, we're going to be looking at principles. And from my perspective, what we're looking at is why it is essential for staff to know the law and why it's essential for the public to pull councils up when they do not act lawfully, instead of just shrugging their shoulders about it, because it's all too difficult to know how this has come about over the last 10 to 15 years. I'm going to be telling people how it's come about with a view to making adult social care a political issue, an election issue, so that all political parties have to be open and articulate about what is a hugely difficult subject. So it will be a roller coaster, but my aim is true. To start off with, how law works in adult social care is a mystery to most people. Most people out there don't even think of social care as something different from DWP benefits, different from social security, that is. But it's a very different species of welfare rights that adult social care represents. And the fact of the matter is, even if they didn't know it when they signed up to be social workers, all social services staff have to do a gatekeeping job. Imagine it's like a farmer letting sheep through the pen before the dip. The gate swings this way and that way, and some people get through and some people don't. They have to do that job because the Care Act, which is the statute that governs adult social care, makes them do that. And that is a truth, even if we are not in a political era where austerity is the background political policy. I mean this. All welfare law statutes in this country are designed to deal with a tsunami of wants and needs and aspirations. They have to have a way of making that flood of demand end up as only a trickle through some kind of filter or a lock gate, as it were. Why? Well, just think about it. It's all publicly funded from taxation. And so the legislative design is that assessment for needs and eligibility decisions, they are the mechanisms for slowing the flood down through that lock gate. And it's adult social care staff, the social workers and the care managers, who have to do that filtering. The law is in this country that social care that is funded by the state, or at least subsidized by the state when you've worked the charging system out, It's for people who either can't arrange it because they don't have sufficient mental capacity, or people who can't afford it for themselves, not in its entirety. So even though the actual services are only for a small number of people, the law is also that everyone, or literally virtually everyone, however well off they are, or however mentally capacitated they are entitled to this thing called an assessment just based on an appearance of need. They don't have to prove anything. They can establish a right to be assessed on a halfway decent, articulate account of their plight. They are entitled to be put through national eligibility criteria, which round out the thinking about how intensely they are in need. And then that determines who gets what. Now, the reason everybody is entitled to an assessment, regardless of wealth, etc., is because of this lovely theory. And it is this, that the expertise and the integrity and the professionalism of the people doing the social work assessment, it's supposed to be good for everyone, regardless, because it's supposed to help them help themselves not fall into a crisis situation in terms of a tragedy or an unexpected mishap or a breakup, etc. Obviously, any country will work better if everyone were to be helped to help themselves before the crisis comes. But why that's so difficult at the moment is most councils have got insufficient staff, and also because the rest of the population doesn't know the first thing about adult social care or the politics going on behind how central government funds it. And I want to reassure you that there are actual legal duties owed to people who are eligible. Eligibility, qualifying for adult social care or the money to buy it, is based on a simple question. Are you unable to achieve in 2 or more areas of daily living activities from a list of 10? You can count as unable to achieve. This is important, even if you can manage the task, but only because you can manage with assistance or significant pain, distress, risk to yourself or to others, or if you need to take extra time for the task. And here comes the good bit. Sorry, not quite. On top of inability to achieve, you have to be experiencing significant impact to your well-being because of your condition. And it's ironic that I forgot that that bit was coming up, because adult social work staff often forget that that's the second bit of the eligibility test as well. And if they bother to apply it and someone becomes eligible, then comes the important legal truth. If you're eligible in this country, your council is obliged to provide you with adequate, appropriate, sufficient care services to meet your needs. And that's regardless of the state of the council's budget, believe it or not, because there's a statutory duty to meet those eligible unmet needs. If we can just take a breath there to read that back to ourselves again, because when you read it, I think it makes you grasp with a light bulb moment why so many councils are announcing approaching statutory bankruptcy. It's because they have a duty that they are obliged to deliver on. In other words, their social services departments have this almost sacred duty that operates regardless of available resources, at a legal level at least, and they are stuck with that. And here's the telling thing. Even though the majority of people in this country have consistently re-elected a government that believes in cutting public services to save taxes, I'm sure we're all familiar with the idea that you can't have your cake and eat it. And the difficulty for me is I have no solution to this problem, I don't think it lies in efficiency efforts any longer. And I certainly don't think it lies in watering down the CARE Act. So, yes, I guess I would be voting to pay more tax. But that's because I am now approaching an age where sooner or later I'm likely to need adult social care. And even if I've made enough money out of being a lawyer in the rest of my working life so as not to deserve a subsidy, I'd still want there to be decent social workers who know what the law is, rather than just relying on artificial intelligence and robots and the internet and Facebook groups. No disrespect to them. Here is the downside of the law. Any council can legitimately take austerity and its own budgetary difficulties into account in deciding how generously to meet your needs. And they needn't do it in the exact way that the person would like. Never mind that the rhetoric is all about person-centeredness and people being their own experts in their own condition. Those are the starting points, but the finishing point is that the councils and ICBs, for people who have got continuing healthcare, they are the decision makers about how much of anything ought to be enough to meet need. Unless you remember that there's judicial review and a whole set of principles underlying the professional governance of the approaches to this question. And I mean by that the law is that if a decision maker who's got their hands on a budget for your needs were to just take an arbitrary approach, such as only 4 visits a day for this person, or no more than the cost of a care home would be, if only we could find one with an actual vacancy. These are not legal offers to make in the first place, and yet this is happening nearly everywhere. Councils need strong leadership and strong management to make clean, principled exceptions to their general strategies to come in on budget and not go bankrupt. They must not give in to whoever it is who shouts loudest or who knows a counsellor. But the trouble is that counsellors in this country are ordinary men and women. They're not experts in adult social care, and they're often tied to the strategies of their political parties in Parliament, and they're not speaking truth to power until it is too late. So the idea behind these podcasts is that we in the general public will only get the adult social care that we need if we can make it over the next year into a political issue that is as important as the NHS is for the fabric of society. And that means we must all stop shrugging our shoulders and merely hoping for better. And we must stomach using law and legal principle to hold public sector decision makers to account. And that's my call to arms. So let's have a look at the principles underlying carers' rights, unpaid, informal family carers. The unpaid care that people do in this country, and in fact anything that a person drawing on services chooses to buy for themselves, those contributions to a person's situation offset the amount of whatever a council is obliged to fund or arrange. Its legal duty is residual. It is what is left over. And the truth in this country is that nobody's relatives can be made to care if they don't want to. But if they are not willing to, or indeed they are not able to, it makes the cost effectiveness of keeping their loved one out of an institutional setting, otherwise known as a care home. It makes it harder to justify out of public money. And councils know that people's carers know that this is the case. Are you in fact a carer? Well, The law is that anyone who is providing practical or emotional support to someone else counts as their carer, even if the cared for person isn't getting any social services or health services as an eligible person, him or herself. And some people don't like to be called carers, but the bottom line is that the status of being a carer means that it opens doors to something that you might not even believe is possible. Paid for support to the carer to enable the carer to keep on going for a bit longer. So that's a sensible plan, isn't it, for the country and for councils? You can be regarded as not just a carer, but as an eligible carer, eligible for some input for yourself if you get exhausted or you feel that you don't want to go on caring or caring at that current level for whatever reason. And if a person wants to be supported as a carer by their council, they can get a carer's assessment to see if they too count as eligible. Are they at risk of significant impact to their well-being because of the load that they've taken on? And if that's the case, then they can get services or money by way of support for themselves so that they can carry on. But here's a key thing. Think about the underlying needy person, the loved one. If they have a care plan of their own and a budget and services, their care plan should be specific as to what those services are for and what the money is supposed to cover. And so if the care plan for the cared for person is specific, it should stop carers being exploited in terms of them just being left to meet whatever shortfall there is. But that will only work if they are listened to, if they say, no, not doing anymore, or if they say, what's going to do that bit then if I don't, because it doesn't seem like the budget will cover the needs. And so if we don't remain clued up about the principles underlying adult social care, then we may well be seen as going on caring from choice. There is a tendency in this country to look at carers who are battling on and taking their continuation to signify that they are willing, at least most of the time. And here's the thing. If we can characterize that willingness as the carer's choice, then that means that the country's councils can manipulate carers into taking on an awful lot more than is actually right or feasible. So that is the real problem. And guess what? It's mainly women who end up shouldering that load, even in 2023. And I ask rhetorically there, with my arch eyebrow, how's that for social progress? Last night, we started off our public cohort legal framework course on a Wednesday evening for a new bunch of students. And we really pulled off a total unexpected first. Every single member of the course who'd paid good money to do it over a period of the next year, every single person was a woman. There was a bloke who signed up right at the last minute, but he didn't make it to the session last night. And I think that that's the most unexpected but telling evidence as to why adult social care is remaining insignificant to political parties. It is because women are shouldering the load. And that makes me absolutely flamingly mad that that kind of change in society should have come about in just, say, 20 years of government policy. So let me warm to my theme then and explain to you what the real problem is. You have to trust me when I tell you, because I have been at it since 1997, that this system we've got has always turned on staff's supposedly professional judgments about people's relative needs, the one compared to the next, and across different client groups, but all managed by different sorts of staff. That's the role that they sign up for. But as money has got tighter, the managers will have got more desperate to make the budgets they've got at their disposal go further, and they will have been inevitably and forgivably less able to keep on top of what's happening to clients from other client groups, or even from the one that they're supposed to be expert in, if they have a regional approach and the county is divided up into north, south, east and west. And at the same time, advice centres all over the country have shut down. Legal aid has been squeezed, and lawyers themselves have ceased to be interested in offering this expertise because they can't make a living from it. In the 8 years since the CARE Act came into force, there have been about 25 or so cases. Before the CARE Act, there were about 60 a year, 60. But the 25 that there have been have relitigated all of the pre-CARE Act principles that had been the subject of cases. So my position is that it's just not professional or legitimate for the staff at the front line or in management or commissioning not to know about those cases. One reason they've got to know about them is that the Ombudsman is now so fed up with councils that the investigators, the bods who used to say this was a missed opportunity for doing somewhat better, they're now being allowed to let rip at councils with much more astute language along the lines of breach of the CARE Act, non-compliant and unlawful under the CARE Act. Even the Ombudsman is obliged to follow the law of this country. And one legal development of great interest, you would have thought to lawyers, since it involves money, is restitution. That translates into money back for breach of the CARE Act. People get money back if they have spent money because the council has thought that it was saving money by doing dodgy things that weren't lawful. And so that's a development that's only happened in the last 4 years. And that's why it's important to have these courses all the time. Even I have noticed, though, that there's a more obvious and pressing problem. There aren't enough people to give the public advice and information. There's not enough people to assess everybody with an appearance of need. There's not enough people working at the provider end of social care to deliver the care plans. And ultimately, we haven't got enough lawyers. Specifically, we haven't got enough lawyers doing legal aid. And so the thing that's branded on my heart is that without remedies, there are no rights. So this system's survival is going to be down to social workers and their values, and to the public saying it is simply not good enough that we forget that we've got legal rights. The body of legal principles that this area of law is all about is called public law, and it runs behind and underneath and through the CARE Act. And it's a very simple principle. These public bodies that we trust to be the decision makers, they get on with it, and we allow their decisions to be legally assumed to be valid and proper after a 3-month period, unless they have been challenged. But to hold on to that presumption that they're always going to get it right, they have to do 4 things. They have to act rationally, lawfully, fairly, and compliantly with human rights. So there's 4 principles that social work staff have to know and their management have to stick to. And all of these 4 principles have been fleshed out over the years by complex litigation. And we're going to look at some of it today, so that just one or two cases, so that I bring the subject to life for you and make you think that you could learn this area of law just from the cases. They involve human beings, winners and losers, goodies and baddies, and they involve judges saying incredibly lyrical, memorable things. And that's more interesting than reading from a textbook, is it not? Why should social work staff even bother if they're all doing three people's jobs and being asked to take pay cuts? Well, quite simply, it makes for better everything. Better customer satisfaction, better governance, better reputations, a better culture for the staff so that they don't all leave after just realizing what a grim job it can be. And if they don't get this right, they end up getting distracted by judicial review, getting savaged in the court of protection, getting complained about to the ombudsman, even being prosecuted or sued for damages, and spending hours in coroner's inquests and safeguarding sagas. So actually, the key to why this matters is that it's like a scythe. Knowing the legal framework helps staff and the public scythe through the waffle. And that's why it must remain alive. As times have got tougher, of course, hearts have got harder. Decision-making has got meaner, and everybody is under more pressure. One worry I have is that staff are more easily able to be put into an arm lock because they are compelled by fear as their own jobs look less secure. So that's what we have got to struggle with. And these are the basic law principles, public law principles that matter. It's the administrative court that people can go to for judicial review. And it's there as a last bastion, if you like, against complete anarchy in a time of austerity. But to go there, you have to be bothered, you have to be brave enough to, you have to afford to, or you have to find a legal aid lawyer who can and will help. To win a case, a public body's decision needs to be choke-worthy to stand a chance of the person challenging the decision winning. Public bodies only have to act defensively. They don't have to act perfectly. And it's not enough that a person would merely like more or a better care package, because as I keep reminding you, it all comes out of everybody else's money. But there's three examples on this slide that will help you. Any decision that would make a judge's eyebrows shoot over the back of their wig, like one toileting visit a week will have to do. Obviously, judges have got bladders, and they know that that isn't going to be physically possible. So ultimately, that's the kind of strong case you need if you're using rationality, reasonableness, as a ground for judicial review. When it comes to making errors of law, it's true that some words in the Care Act are left for councils to interpret within a margin of error. So they could stretch the meaning of the word significant in the context of significant impact, or they could shrink it until they made a ridiculous or an outrageous interpretation. But then there's other words in the Care Act, words like the word support, and that's been said just in the last year to be the kind of word that the judges are the last determinant of as a matter of law. And that case, which was the Suffolk case, helped broaden the scope of the Care Act to provide for last-ditch financial assistance to people for whom there was no other way of meeting their needs. Finally, councils have to act fairly. They have to be taught to say, we generally or we normally, not that we never or we always, because there's a rule against fettering of discretion. If a policy firms up into a rule that no staff ever think of departing from, then that's a ground for judicial review in itself. It boils down to this: management can't tell the frontline staff how to think and still go to court and say, my frontline's professional opinion was such and such. And that might come as a surprise to a lot of people in this presentation, I suspect. So the bottom line is that it's quite hard to lose a judicial review if one is a council or an ICB. It might happen if the management is completely uninterested in keeping the staff up to date. I have got 2 slides of tendencies to look out for in local practice, but I'm not going to spend time on them because I want you to sign up for our roundup, which involves parting with £25 for a whole year, and then you will get these slides. I expect some people have been photographing them, but we all know that all is fair in love and war, and that's fine with me. However, I want to spend my last few minutes on the actual case law, because this is going to bring it alive for you that the carer's willingness is the be-all and end-all for the size and the content of the service user's own care plan. And it's a case involving North East Lincolnshire. It involved a young woman who needed to be somewhere during the day, somewhere useful, and the council paid for an escort for her to go to a daycare centre. But they wouldn't pay for the place at a daycare centre, and they argued with their education department as to whether it was educational services or whether it was just somewhere to park the lady or whether it was a social service. How did she even get through the front door if they weren't paying? Well, it turns out that it was a charity, and she was related to somebody who was the founder of that charity. So he was able to open the front door and let her in and think about who to sue for the money for the place later. Case law often turns on little juicy details like that. And the judge found this when there was a challenge. Everybody's personal budget must be transparent and explicit. Even a starter for 10 indicative personal budget has to be comprehensible. Informal carers' willingness must not be assumed. Some of the plans in this family's case for the young woman that they were arguing about prior to the final one, those plans had failed to state a personal budget at all. None had any breakdown of the overall figure. And the judge held that that lack of clarity in the personal budget was a breach of the Care Act. The duty to state a personal budget implicitly means a transparent figure that explains how the needs can be met. And this way, of course, you can see what is being expected of any family carer, the informal assets and strengths. And the judge said this: the duty is a clear one, derived from Section 26. Any failure to provide a transparent budget represents a prima facie, an in-your-face breach of that duty, which would be susceptible to legal challenge if it was otherwise uncorrected. The judge stated that an adult's family carer is under no obligation to meet the eligible needs of the adult, and any care plan must be contingent on any such care that is being offered being withdrawn, or upon the local authority realizing that the person is not in a position to cope with caring any longer.
In those separate placements.
Somebody is unfortunately unmuted. There we go. So you might think that this was a good enough victory for the family, but you're going to remember that there's a charity behind this daycare centre that hasn't been paid for the place. So the family went to the Court of Appeal and won a case for the fee for the placement to be retrospectively paid back. The Court of Appeal, a higher court in this country than the High Court, held that if there is a breach of the Care Act, it must pay what it would otherwise have been obliged to pay towards the person's care plan if it had acted lawfully. Not just because it didn't pay it at the right time, but because in any case where services have been used, someone will have incurred a liability to pay. Here we had the young woman who was being admitted to the daycare service, albeit by her dad, and she was taking up a place that the charity could not do without being paid for. It would have been unlawful anyway and unethical of her dad to just give her a place for free. And in that situation, she theoretically owed the charity, and the judge said, therefore, that the council theoretically owed her the money. I love this. The judge said this: a breach of a statutory duty is a breach of a statutory duty. Duh. It is by definition unlawful conduct, and such conduct by a public body cannot merely be discounted or ignored. Section 26 is no minor matter. It is absolutely fundamental to the operation of the scheme which the Care Act underpins. And this is the key part. So in the present case, having found the council to be in breach of its statutory duty, the judge in the High Court below should have gone on to hold that the council had acted unlawfully and accordingly was liable in principle to compensate the young woman in respect of any monetary shortfall in accordance with blessed, normal public law principles of legal accountability of public bodies. 3 cheers for Lord Justice Haddon Cave. So I'm thinking as we come to the end of the session that it's very cheering for a service user who's spent money, or for families that have just been forced to step up. But at the same time, it should be pretty scary for councils if they know about this legal development, because where there is a risk of being sued for money, guess what there is? Lawyers. Now, this case is not just a one-off. It's been followed in 2022 in P versus Croydon Council. Croydon has had an extremely bad run of ombudsman's complaints and litigation over the last year. Something has gone very badly wrong there. I think that there are commissioners sent in by central government, and it could be that they know even less about adult social care legal principles than the previous bunch of staff did. The litigation and the ombudsman's outcomes would make it possible for me to say that that is a feasible explanation rather than just being slanderous. Croydon Council had decided in an earlier plan for Miss P that 35 hours a week was enough for her, but believe it or not, they'd only paid for 30. So that was the difference of 5 hours at £12.50 that they had to cough up. The woman was then reviewed for the future because she had gone through a big change of circumstances. But second time around, Croydon messed up in a different way. It accidentally wrote down that the care plan budget should be for the full 96 hours a week of care that this woman would need if she wasn't living at home with her parents. And then, of course, the parents said, yes, thank you very much. We'll take that 96 hours. No, Croydon said. We were actually thinking that we could just go on paying you for 35 hours a week, and that would be enough for your daughter, even though her situation is radically changed. We never meant to say that we would provide £1,200 a week for 96 hours. We just made a terrible mistake. So this dispute happened because Croydon's staff steadfastly avoided having a proper conversation with the family. And I don't disagree. The gap between 35 and 96 is massive. And the reality was probably halfway between the two because, of course, the family were still willing to do lots and lots for their daughter, but not everything. So the court wiped out that 35 hours care plan for the future and sent the council back to the drawing board. That meant that another period had gone by since the 30 versus 35 hours deadline. Another period had gone by the time the case got to court, with the parents having been forced into shouldering the work that the state should have paid for. So I have done some sums on my calculator, and I think that if you take, for example, that we have 150 councils in this country, and every council will have probably got maybe 50 people who could sue them for restitution for sums between 50 and £5,000 each, we are looking at a conservative estimate of adult social care needing to find £50 million to pay back to people. But it doesn't happen because lawyers haven't kept up, and because most people are afraid of challenging their counsel. Now that brings me to an end of the actual material that I have got. We have got some points here about CASCAIDr, which I will leave up. And in the meantime, I'm just going to look at the chat questions, and I would invite people who can stay on to decide whether they would like to stay on and unmute and ask further questions. But let me do the ones in the chat first, okay? I know it's only supposed to be 45 minutes, but we had no idea how many people would turn up. We had no idea whether I could hold myself in or not and stop talking for England. Still not sure about that. But I'm going to look at the chat questions now, okay? So I have got lots of people just talking about the logistics, but then saying that the stuff was very informative. Can we see the CARE Act and principles as tools for social workers to act defensively? Absolutely. I said, didn't I, that it's like a scythe, it's like the scalpel. Imagine in a professionals meeting, you've got somebody saying, should we do this or should we do that? Somebody who can say, well, we could do this or we could do that, but we definitely can't do that other possibility, has already saved a lot of time, hasn't it? And that is really important. So I think that we could be more efficient if we hadn't lost sight of CARE Act principles. Kath from South Yorkshire has said she's used the knowledge from attending these trainings and she advocates for herself and for other people. She frequently finds that she knows more about how systems should work than the staff using the systems, and she struggles, but she manages to remain diplomatic. Her idea of the core definition of diplomacy is telling someone to go to hell in such a way that they actually look forward to the journey. And I'm going to remember that because I think it's going to come in handy over the next year before the election. So it will be really interesting to read some of your other questions. One from somebody called Gribin H is a comment really that the Secretary of State does not have a duty and only a power to have an appeals process relating to the CARE Act. And that is true, and it's incredible. And that's why people have to use judicial review. There is no appeal against an adult social services decision. Some local authorities are using a sort of an appeal process, but not because they have to, but because they think that it makes sense. There are some more specific questions which I won't be able to answer because the questions, I'm afraid, have to be related to the general topics of the theme for the week. There is one that is about what are my thoughts about core hours tied to a specific care provider, divided equally across a number of people and never reviewed at a CARE Act annual review. And I cannot resist answering that one because I actually know the very interesting relevant section number, which I think most people will never have seen. If you look up the Care Act and you go to section 2511, you find that it says that local authorities are welcome to combine people's care plans and thus their budgets, but only if every single person agrees. And if James's question is with reference to people in supported living or people in extra care, and it's likely that those people have a cognitive impairment, the next obvious question would be, how has their agreement been sought? You might think that there's provision for a deputy or a power of attorney holder to make a decision as the statutory agent of the person, who is, after all, the person who's likely to want that loved one to be in a good setting for supported living. But you can look at section 2511 until the cows come home, and you will not find any process for substitute decision making. And this leaves me with the legal conclusion, although I know of no case on it, that in fact, budgets in supported living cannot actually be shared without a person's agreement, and therefore cannot be calculated other than individually. And if that isn't enough to actually send shockwaves through the supported living commissioning sector, I don't know what is. So I hope that Kath thought that that was diplomatic. I am going to finish now, and I'm going to just leave the session for 2 minutes on the logistics at the very beginning of the slides, so that you can take a photograph of them again and understand how to follow up. So these are the means for obtaining the recording, obtaining the slides, hearing from us ever again if somebody shoots me. I hope that doesn't happen, and also how you can support us. So I hope that you'll come back next week and for the next 12 weeks after that. I'm hoping that you'll spread the word, and we will one day have 500 people and not just 100. Okay, thank you very much. Bye.